If you are a naturalized United States citizen, 2026 may feel like the most stressful year you faced since the day you raised your right hand and took the oath. Over the past several weeks, headlines, social media clips, and especially viral WhatsApp forwards have pushed one alarming claim after another that the Trump administration's new immigration agenda could put naturalized citizens at risk, that citizenship is no longer secure, that denaturalization is quietly expanding, and that people could lose what they worked years to obtain. Some of what you're hearing is exaggerated, some of it is misunderstood, and some of it is rooted in real changes. Not changes to the Constitution, not a brand new law that suddenly cancels citizenship, but real changes in enforcement posture, data sharing, and investigative priorities. The problem is that fear spreads faster than facts, and when enforcement becomes louder, stricter, and more visible, it gets harder to separate rumor from legal reality. So the real question is this: can your US citizenship actually be taken away in 2026? Are naturalized citizens being targeted? And what has truly changed under President Trump's renewed immigration agenda? Not politically, not rhetorically, but legally and operationally. Because there is a huge difference between campaign language, agency priorities, executive power, and constitutional protection. And if you don't understand those differences, it's easy to panic. Today we're going to break this down clearly and calmly. What's new, what isn't new, who is genuinely at risk, and what you should and should not be worried about right now. Hi, I'm Sophia, and welcome back to US Entry Point, where the goal is simple: to give you clear, legally grounded, and up-to-date immigration information without political spin, without sensationalism, and without fear-mongering. Immigration policy in 2026 is moving fast. Procedures are being updated, priorities are shifting, and court challenges are unfolding. When that happens, confusion spreads quickly, especially inside immigrant communities where people are understandably protective of everything they've built. Before we go further, we need to separate something that gets blurred in almost every public conversation about immigration: political messaging versus legal authority. Yes, this administration has made enforcement a top priority since early 2025. Yes, agencies have been directed to tighten review in certain areas. And yes, resources have been steered toward enforcement units. All of that is real. But what is equally real is that campaign rhetoric is not the same thing as constitutional law. A president can change enforcement intensity. A president can redirect agency resources. A president can reinterpret certain regulatory standards within existing law. But a president cannot rewrite the Constitution with speeches or social media posts. The US legal system is built on structure. The executive branch enforces laws, Congress writes laws, and the Constitution limits both. That distinction matters more than anything else in this conversation because it stops fear from turning into fantasy. When people hear that enforcement is increasing, some jump to the conclusion that rights are disappearing. That's not how the American legal system works. Enforcement can become more aggressive, but constitutional protections don't vanish just because an administration is stricter. So what protects a naturalized citizen in the first place? The answer begins with the 14th Amendment. It states in plain language that all persons born or naturalized in the United States are citizens of the United States. The phrase born or naturalized is not decorative. It doesn't create two tiers of citizenship. It doesn't imply that one type is permanent and the other is conditional. Once someone is lawfully naturalized, they stand on equal constitutional footing with someone born in the US. Equal rights, equal protections, equal status under the law. Now, does that mean citizenship can never be revoked under any circumstances? No. And this is where nuance becomes essential. There is a legal process called denaturalization. Denaturalization is not new to 2026. It has existed for decades. The key is understanding what denaturalization is actually about. It is not designed to punish someone for being a citizen. It is designed to correct a citizenship grant that, according to the government, should never have been granted in the first place because of fraud or illegality in the naturalization process itself. Under the law, the government may pursue denaturalization if citizenship was illegally procured or obtained through concealment of a material fact or willful misrepresentation. Those words carry specific meaning. Willful means intentional. Material means significant enough that it would have affected eligibility. This is not about minor paperwork errors, small misunderstandings, or forgetting a short trip. It is about deliberate deception that would have changed the outcome. And here's the part that calms a lot of fear when people finally understand it. Even if the government believes fraud occurred, it cannot simply cancel citizenship administratively. It must generally file a case in federal court. That means a judge is involved. Evidence must be presented. The burden of proof is on the government, not on you. And it's not a light burden. Courts require clear and convincing evidence, which is higher than the standard used in most civil cases. You have the right to hire an attorney. You have the right to defend yourself. You have the right to present evidence and challenge the government's claims. And if the court rules against you, you have the right to appeal. Historically, denaturalization has been rare. For many years, the number of cases was measured in dozens annually, not thousands. These cases often involved serious misconduct, concealed war crimes or human rights abuses, terrorism-related issues, fake identities, or proven large-scale frauds such as sham marriages that led to residency and later citizenship. The reason these cases were rare is also the reason citizenship is treated seriously. Stripping someone of citizenship is considered one of the most severe civil actions the government can take. Courts do not treat it lightly. So if constitutional protections are strong and the legal standard is high, why is there so much concern in 2026? Because the Constitution hasn't changed, but enforcement posture has. And enforcement posture can change how often old cases are investigated and brought to court. That is the shift we are seeing, not a rewriting of citizenship law, but a more aggressive use of an existing legal tool. Since early 2025, resources inside federal agencies have been directed towards stronger fraud review and more aggressive identification of cases where citizenship may have been unlawfully obtained. Another major change is technology. Government systems are far more integrated than they were 10 or 20 years ago. Data that used to sit in separate silos, immigration filings, criminal databases, identity records, and sometimes international information, can now be cross-referenced much faster. That means older naturalization files can be reviewed against modern databases in a way that wasn't practical years ago. So what does that mean in real life? It means if someone used a false identity decades ago, modern biometric systems can detect inconsistencies. If someone concealed a serious conviction that later appears through information sharing or updated records, it can be flagged. If someone's immigration history contains contradictions across multiple filings over many years, those contradictions are easier to locate. In short, the system is more capable today, and this administration wants those capabilities used more aggressively. But here is where social media often goes wrong. Increased review does not equal mass revocation. Even with expanded enforcement, we are still talking about a limited number of cases compared to the tens of millions of naturalized citizens in the United States. Most naturalized citizens will never be contacted, never receive a notice, and never face a challenge to their status. So who is realistically at risk? This is the most important part of the entire discussion, and we need to be precise. The cases most likely to be prioritized fall into narrow categories. First, people who knowingly lied during the naturalization process about something material, something that would have affected eligibility. Second, people who obtained permanent residency through proven fraud, like a sham marriage, and then naturalized based on that fraudulent foundation. Third, people who used false identities, fake documents, or multiple identities during immigration processing. Fourth, people with serious national security issues, terrorism-related grounds, or concealed participation in human rights abuses. Now let's correct a myth that spreads fear quickly. Crimes committed after naturalization, by themselves, generally do not cause automatic loss of citizenship. If someone becomes a citizen lawfully and later commits a crime, they may be prosecuted and imprisoned, but they do not automatically lose citizenship simply because of the later offense. The exception is if that crime reveals that the person lied during the naturalization process or concealed disqualifying conduct from before naturalization. The focus always returns to procurement, how citizenship was obtained. Another major myth is that speaking your native language, holding dual citizenship, criticizing the government, or traveling to your home country can jeopardize citizenship. There is no law that revokes citizenship because you keep your culture. There is no statute that strips citizenship for political disagreement. The First Amendment protects speech, including criticism. Dual citizenship is generally permitted, even if it can complicate certain situations. And travel to your home country is not grounds for denaturalization. There is also fear circulating that certain nationalities are being broadly targeted. While it's true that some regions may face heightened security screening and visa processes, there is no statute that allows blanket denaturalization based on national origin. Denaturalization requires individualized evidence of fraud, not ethnicity or birthplace. So the honest picture is this. The vast majority of naturalized citizens who were truthful, who met eligibility requirements, and who did not conceal disqualifying information are not facing a realistic legal threat. The people most vulnerable are those whose original immigration path contains deliberate material deception. Now, while denaturalization affects people who are already citizens, another important shift in 2026 affects those who are still applying for citizenship. USCIS has intensified vetting for new N-400 cases. Interviews can feel more detailed. Officers may spend more time reviewing travel history, employment records, tax compliance, and consistency across older applications. Requests for evidence have become more common in cases with complicated histories. Processing times have also lengthened in many jurisdictions. This doesn't mean approval is impossible. It means scrutiny has increased. Officers are documenting more. Supervisors may require additional review. Background checks can take longer. And the key difference is this. The test may not feel harder, but verification is deeper. If your interview answers don't match older filings, it can trigger follow-up questions. That doesn't automatically mean denial, but it means preparation matters more than ever. For green card holders, this distinction is critical. Permanent residence is not the same as citizenship. A green card does not carry the same constitutional permanence. Lawful permanent residents can lose their status under a broader range of circumstances. Certain criminal convictions, extended absences, abandonment issues, or misrepresentation. Citizenship is the strongest layer of protection in U.S. immigration law. That is why, if you are eligible for naturalization, applying can be a strategic move. But in 2026, you must approach the process carefully. Review your full immigration history. Confirm you meet continuous residence and physical presence requirements. Make sure your tax filings are consistent with your claimed residency and work history. If you have any arrests, even dismissed, obtain certified court dispositions. If you have prior immigration violations or complicated travel patterns, consult an experienced immigration attorney before filing. Enhanced scrutiny does not mean automatic denial, but it does mean preparation is no longer optional. Now let's address a question many people quietly ask. What if someone is actually contacted by the government? What rights do you have if your citizenship is questioned? And what should you do in a way that protects you instead of making things worse? If you are contacted by a government agency about your citizenship, whether it's USCIS, the Department of Justice, or an investigator, the most important thing to remember is that you have rights. First, you have the right to remain silent, and you have the right to counsel. You are not required to answer questions immediately without legal advice. You can calmly say, "I would like to speak with an attorney before answering." That is not guilt, that is protection. Second, if the government initiates denaturalization proceedings, it generally must proceed through federal court. You have the right to hire an attorney and defend yourself. Third, the burden is on the government. They must prove their case with clear and convincing evidence. Fourth, you have the right to appeal. These cases can move through multiple levels of courts. The system is layered and outcomes can change. The process is not a one-step administrative cancellation. Now let's talk practical preparation. Even if you believe you have nothing to worry about, being organized is smart. Keep your immigration documents safe and accessible. Your naturalization certificate, copies of your N-400, your green card history, prior visa filings, approval notices, and any correspondence. If you naturalized years ago and don't have copies, you may consider filing a FOIA request to obtain your immigration file so you know what was submitted. If you have any complex history, prior arrests, immigration violations, identity issues, long absences, or inconsistencies, It may be wise to consult an immigration attorney proactively. This does not mean you are in danger. It means you are informed. An attorney can review your file and tell you whether anything creates real risk under current enforcement priorities. Also, do not ignore official notices. Deadlines matter. People sometimes assume a letter is a mistake or spam. Delaying response can create bigger problems than the letter itself. If you receive any communication referencing your citizenship status, act quickly and get professional counsel. For those who are not yet citizens, there is another important warning. Never falsely claim U.S. citizenship on any document: voter registration, job forms, government benefits forms. A false claim to U.S. citizenship can carry severe immigration consequences and is far harder to fix than many other issues. If you are unsure how to answer a question on a form, consult an attorney before submitting. Now let's step back emotionally, because fear isn't always about statistics. Many immigrants worked for years to secure residency and citizenship. The idea that it could be questioned feels deeply personal. But the best antidote to anxiety is understanding structure. Due process still exists. Evidence is required. A judge is involved. The government carries the burden. Enforcement intensity may rise or fall across administrations, but constitutional safeguards do not disappear overnight. And this leads to one of the most important distinctions in 2026: the difference between the security of citizenship and the vulnerability of permanent residency. A green card is strong, but it is not as strong as citizenship. Permanent residents face lower legal thresholds for status loss compared to the high standard required for denaturalization. That is why eligible permanent residents should view naturalization as a protective step, after careful preparation. Now, another major anxiety point in 2026 is family-based immigration. Many naturalized citizens have pending petitions for spouses, parents, children, or siblings. Under a stricter enforcement climate, family-based cases can face increased scrutiny. That doesn't mean family immigration is gone. It remains part of the legal framework. But documentation matters more. Requests for evidence can be more frequent. Interviews can be more detailed. Financial sponsorship requirements can be examined more closely. Backlogs remain in many categories, and enhanced background checks can add time. If you have a family petition pending, stay proactive. Respond to requests for evidence completely and quickly. Keep financial documentation organized. Communicate with your attorney if you have one, and avoid reactionary decisions based on rumors. Some families withdraw applications out of panic or delay filings unnecessarily. Unless there is a specific legal reason to pause, decisions based on fear can create more harm than protection. As we look through the rest of 2026 and into 2027, enforcement will likely remain firm. Additional directives may shape agency priorities. Court challenges will continue. Some policies may be narrowed or blocked. Immigration policy in the U.S. has always moved in cycles. What remains constant is the legal structure that requires statutory authority, due process, and judicial oversight. Now let's close with the bigger emotional question many people are silently asking. Is the American dream still accessible, or has the system fundamentally changed? Immigration in the U.S. has always been politically charged. Different administrations emphasize different priorities. Some focus on expansion, others on enforcement. But one consistent feature across American history is structure. Policies shift, scrutiny rises or falls, but constitutional protections don't vanish because of a news cycle. We are already seeing immigration directives challenged in federal court. Some policies are narrowed, some are blocked temporarily, others proceed. That is not proof the system is broken. That is proof the checks and balances are functioning. For naturalized citizens, the core truth remains. Citizenship lawfully obtained is highly protected. Denaturalization is not casual. Courts treat it seriously. The standard remains high. The overwhelming majority of naturalized citizens who were truthful and eligible are not facing realistic legal threat. For green card holders and applicants, the environment may feel tighter. Longer processing times, deeper interviews, stricter documentation review. But approvals continue every day. Families are still being reunited. People are still taking the oath across the country every single week. That reality rarely goes viral because calm approvals do not generate fear-based clicks. So what does all of this mean? It means citizenship obtained honestly remains secure. It means green card holders should prioritize compliance and consider naturalization when eligible. It means applicants must prepare more thoroughly. And it means rumor and panic should not drive life-altering decisions. Knowledge is stabilizing. Structure is stabilizing. Due process is stabilizing. Immigration policy in 2026 is stricter in tone than some past years, but stricter enforcement does not equal lawless enforcement. And it does not erase constitutional safeguards that have been tested repeatedly for generations. If you want the strongest practical protection in this environment, focus on the things you can control. Keep your records organized, ensure your filings are truthful and consistent, consult a qualified attorney if you have any complicated history, and do not ignore official notices. The goal is not fear, the goal is preparation. Because in 2026, preparation is power, and clarity is the best defense against panic.